ESI, interview custodians. Lots of good reasons to do it. Locate the relevant ESI. You build your preservation obligations and legal hold obligations from the custodians to meet the Zubulake requirements or obligations. I'll talk about that in the next slide. And another reason is to address, have somebody talk to the custodians early on and address possible anxiety. Many people, when they receive a legal hold notice, if they're not used to it, can become very anxious about it and can spin. So it's an opportunity to talk to them, control the narrative, explain the process, answer their questions early on. Another key reason is to gather facts and do your initial case assessment. As cases have gotten larger and larger, it's harder and harder to understand all the key documents early on in the case, and more dangerous to wait as the case develops. So anything one can do early on to start building one's narrative, one's story, do timelining, and have a consistent theory of case early is very important, and that can be done very well with early custodian interviews. From the custodians, if done properly, you'll identify the data stores and allow for data mapping of the available ESI in a case, and we'll talk about that later, so I won't address it here. Prepare for collection of the ESI. Plan ahead for discovery obligations. How long is it going to take? How many custodians? What can be committed to? What's it going to cost? All these can be fleshed out with the beginning stages of good custodian interviews, and prepare for meet and confer and other discovery obligations as one goes in. So I'd put this all under the general category of GIGO, garbage in, garbage out. As you're building up your case, if you don't do a good job at this on the front end with a complex case, it's going to be very difficult to go back and get to the same level otherwise if you try to pick it up at a later time. The next slide will talk about the Zubulake obligations, a very famous series of cases that are the basis for modern e-discovery law, certainly at the federal level and a lot of the state levels, and has been the ideas have been integrated into the rules, but it's good to go back and read the original case and understand where it was coming from and what the reason was. From the Zubulake obligations, we get the litigation hold when the duty arises, when litigation is reasonably anticipated, that hold should be issued, obligation to interview data custodians, etc. The basis for this is the attorney's obligation to the court, and in Zubulake, the court was saying that it's not possible for the attorney to disclaim any of this not being done properly, and that there's an affirmative duty on the attorney to make sure that this happens. So that was the thinking of that, and that's carried over to today. All of these Zubulake obligations, discovery obligations are difficult or impossible to do well if the custodians' case participants aren't adequately identified and data interviews from them early in the process.